Suppose you're facing a felony charge in California. What are you looking at? What is the most you could possibly get? The answer to your question might be a little bit more complicated than initially thought. We're going to try to address part of that in this and a couple of other videos. Sentencing in California, I found, can be quite complicated. Even seasoned lawyers and judges often routinely make mistakes or misstate how a sentence is formulated. And felony sentencing, because the stakes are much higher, I think that contributes to the complexity quite a bit. It doesn't necessarily mean that people are getting draconian sentences all the time that are disproportionate to the conduct, but it's just the act of verbalizing, choosing the right words to describe the sentence, what you have to do, can often be just really complex. So I want to talk about a couple of basic principles of felony sentencing. And that is, how do you find out what is your maximum possible sentence in a given case, or your total exposure, as lawyers often say? So let's say you're facing a California felony charge or Penal Code Section 245A1. We're just going to use that as an example. If you just look up that statute, which anyone can do online, you'll see that you could get sentenced to 2, 3, or 4 years of state prison. So you might think, easy enough, the maximum exposure is 4 years. And in reality, it only answers part of the question. In the United States Constitution, you have a right to a jury trial where the government has to prove its case against you beyond a reasonable doubt. Now, you might be thinking, what does that have to do with this issue of sentencing? After all, we think of a jury trial as something where it's like, well, are you guilty or are you not of the crime? And what does the government have to do to even get you found guilty? Well, it's actually interwoven with the concept of what is your maximum exposure and what is your maximum sentence in a California felony case. In the case of Apprendi versus New Jersey, the United States Supreme Court ruled that any factor that increases a defendant's maximum possible punishment is something that has to be put to a jury with proof beyond a reasonable doubt, unless the defendant otherwise admits to or pleads to that factor. In Apprendi, as you might be able to know from your own research, the situation was a man was charged with some sort of assault crime which carried a certain type of maximum. And on top of that, the government wanted to see him get an additional couple years of punishment on the basis that it was a hate crime. The jury found him guilty of the assault charge. A judge determined that he did act with some type of racial animus. And on the basis of that, the judge gave him an additional years pursuant to that enhancement. The U.S. Supreme Court said this was not okay, because if they wanted to expose him to that extra slice of years, they had to be able to at least give him the chance to prove or disprove that issue to a jury, and the law didn't allow for that. So how does this apply to our situation here? You're facing a charge of California Penal Code 245A1, assault with a deadly weapon. You could get 2, 3, or 4 years of state prison. Well, in order to even justify that 4-year maximum sentence, the government has to be able to prove that at least one of several different aggravating factors was present in the crime. Some of them are, for example, whether the defendant took advantage of a vulnerable victim, or whether the defendant's criminal behavior appears to be increasing in severity over time. There are kinds of factors that feel very common sense, but the rules also say that you're not allowed to impose the maximum upper term unless at least one aggravating factor is present. If it's not there, they can't get you to that upper term. And the statutory maximum in some ways might actually be only the middle term. In our example, the 3-year term of the triad for 245A1. So as you can see, we can really go down a rabbit hole for all the different combinations of things that can happen with felony sentencing. Obviously, if you're facing a felony charge, or really any criminal charge in California, you gotta ask your lawyer the basic question: what am I looking at? And a good lawyer should be able to answer that question intelligently. It may not be a very short answer, but thorough answers rarely are. And if you're facing a felony charge, you need to have a lawyer at your side who can adequately navigate these complexities and avoid any unnecessary confusion, and more importantly, any unnecessary punishment or repercussions for your case. I hope that this was helpful. For more information, feel free to check out our YouTube video. Thanks, and stay safe out there.